Right, ladies and gentlemen, thank you very much for joining us. So this is a talk from Grahame and I, which follows on from a talk which we delivered to Littleton's Employment Extravaganza seminar, where we were looking at the new duty to prevent sexual harassment. And when we delivered the talk previously, we indicated that it was likely to be something that we would periodically update in order to point out the developments in this new duty. So can I say, in terms of our approach to the talk, as regards questions, if you have any questions, we anticipate we will have some time at the end of the talk to address any questions. So if you could place the questions in the chat function, I will seek to moderate those questions because Grahame's going to be speaking on the last issue, and then hopefully we should be able to address any questions that you have at that point. Moving on to the next slide, please. What we're going to do is effectively look at 7 issues. I'm going to deal with 1 to 3, which is looking at the wording of the statutory provisions and seeing what, if anything, that points to in terms of the precise scope of the new duty. Grahame is then going to engage with the difficult question, if I could put it that way, of what it is precisely that the employer is required to do. He'll also look at the question of how compensation will work, which may require a certain degree of crystal ball gazing, but we'll see how we go. Then we will look at the new proposed EHRC guidance and seek to analyse the extent to which that is or is not consistent with the provisions which have been enacted. And then I'll take the perspective of claimant lawyers and how one may use this new duty to the advantage of one's clients. And then Grahame will adopt the position of the respondent and see how you might meet those particular arguments. So next slide, please. So, important thing to recognise is that the new duty to prevent sexual harassment is not yet in force. It comes into force on the 26th of October 2024, which is not that long away now, and it amends the Equality Act to create a new duty on employers to take reasonable steps to prevent the sexual harassment of their employees. And for the remainder of this talk, I'll refer to that as the new duty. It then, rather like ACAS uplift, envisages that in circumstances where there's been a failure to comply with the new duty, tribunals have the power obligation to uplift compensation by up to 25% when that duty's been breached. But the important thing to recognise is this new duty creates no freestanding causes of action at all. It's entirely parasitic upon an existing claim, to that extent, rather like the ACAS uplift approach. The new duty can also be enforced by the Equality and Human Rights Commission using its enforcement powers. And it's important to recognise that the House of Lords, when amending this bill in its passage through Parliament, removed a clause that would have restored the old third-party harassment provisions under Section 40 of the Equality Act, which were repealed in 2013. They also removed the requirement to take all reasonable steps to prevent sexual harassment. You now only have to take reasonable steps. And in due course, Grahame will wrestle with whether that distinction actually matters, and if so, the effect of it. Next slide, please. So, looking at the wording of the statutory provision, Section 40A of the Equality Act, an employer must take reasonable steps to prevent sexual harassment of employees of A in the course of their employment. Sexual harassment is then defined in accordance with the existing definition of sexual harassment in section 26(2) of the Equality Act, i.e. unwanted conduct of a sexual nature. So, points to note from that wording, as I've already foreshadowed, the duty is to take reasonable steps, not all reasonable steps. It's also on its face a general duty because it speaks about preventing sexual harassment of employees of A in the course of their employment. Interestingly, no specific perpetrator identified, but as I've already pointed out, remember the reference in section 26(2). And even though the restoration of the third-party liability provisions was not pursued, on the face of it, the new duty extends to preventing sexual harassment from third parties. Now, this was a nuanced question. Parliamentary sponsors of the bill said that the effect of it was to prevent third-party harassment, and certainly, as we'll see in a moment, that is the view of the Equality and Human Rights Commission. Next slide, please. So, obvious point to make is this all might be feeling a little bit familiar, because the wording of the provision bears at least similarities with the existing statutory defence under section 109(4) of the Equality Act, which provides that in proceedings against an employer in respect of anything done by an employee, it is a defence for the employer to show that B took all reasonable steps to prevent the person from doing that thing. So points to note is, on the face of it, similarity between section 40A and section 109(4. And it is to be recognised from, I dare say, our collective experience that the statutory defence is a very high threshold. Very seldom succeeds because you need to demonstrate that you've taken all reasonable steps. Now, the difference in wording between 109(4) and 40A obviously connotes an intention that there ought to be a difference of application in terms of the statutory defence as opposed to the new duty to prevent sexual harassment. Also note that in section 109(4, the steps must be targeted at protecting A from harassment by B, i.e. the employee of the employer, rather than sexual harassment at large. Also, the duty under section 100, or the defence under section 109(4 has to be specifically pleaded and advanced in order for a tribunal to determine it. That's not the case with the new duty. This is a freestanding obligation which is placed on tribunals. Next slide, please. So I'll hand you over to Grahame, who will now look at the compensation provisions and take matters forward from there. Thanks, Grahame.
Thank you. Hello, everyone. So let's deal with section 124(a), which is the interesting and very tricky part of this, of how this new duty is going to work in practice. Obviously, we're still at a stage where we are slightly crystal ball gazing about how tribunals are going to approach both the new duty and what it entails, and how this compensation uplift that Nick alluded to earlier, we still don't know exactly how it's going to work, and we'll keep an eye on that. I think we can make some sort of general pronouncements on the basis of what the Act says, but also on the basis of tribunal experience with these sorts of things. Look, first of all, at 124(a) 1A. So the section applies where a tribunal has found that there has been a contravention of section 40. And section 40 is just harassment per se. It's not specific to sexual harassment, any sort of harassment. So if you are in a world where a claimant has succeeded on a claim of harassment of any sort, boom, 124(a) potentially applies, which involved to any extent harassment of the kind described in section 26(2). So already there's a disjuncture, isn't there, between what the claimant has to have succeeded on, section 40, any kind of harassment, and then harassment of the kind described in section 26(2). So what it doesn't mean is you have to have succeeded in a claim of sexual harassment before the provision applies. You have to have succeeded in harassment of any sort. And then the question becomes, did it involve, query what that means, to any extent, query what that means, harassment of the kind described in section 26.2. And Nick hinted at this point about section 26.2 a moment ago. It would appear that you do not need to be in a world in which the harassment was of a kind that would have succeeded as a claim or was actionable as a claim. But section 26.2, of course, only deals with sexual harassment that is actionable. And the only kind of sexual harassment that is actionable, as Nick hinted at, is worker on worker rather than third party on worker. But as we will see, first of all, in the development of the bill, those people sponsoring it through Parliament said it would cover third party harassment. We'll see in a moment that the EHRC guidance very squarely has that in mind. But also this use of the expression of the kind described rather than saying sexual harassment as defined in section 26.2 or actionable sexual harassment rather implies that it's broader than purely actionable harassment. So that's the first point. The second point, what does this involved to any extent mean? Well, again, it doesn't mean that you have to have succeeded on it. It has to, it's somewhere in the story would appear to be the rather low threshold. And I'll come in a moment to deal with an example that might be instructive. What we then go on to consider, if you look at subsection 2, is whether and to what extent the respondent also contravened section 48. That's the duty to take reasonable steps. Now, again, another disjuncture. There does not appear to be a requirement for any sort of connection, causal or otherwise, between the failure to take the reasonable steps and the harassment of the kind described in section 26.2. So what do I mean by that? What I mean is, it does not matter if the employer took all manner of reasonable steps, every conceivable reasonable step that would have prevented the sexual harassment that was involved in the story. Say they did do that. Theoretically, if there is a failure elsewhere, you are nevertheless in the territory where you have contravened section 40, and therefore theoretically there is potential for this provision to apply. Indeed, this, as you can see, and no doubt Nick will address in a moment, there's a great deal of scope for a claimant and for a claimant lawyer to say, well, it doesn't matter that you did everything you could to protect me or my client, because in the office 3 doors down the road, something else happened which had nothing to do with me, but nevertheless amounts to a breach of this section. So again, we see these disjunctures arising, which are going to create uncomfortable discussions within respondents. Now, as I say, we've got to look at what it means for there to be sexual harassment involved to any extent in the story. But it's very difficult to know just how involved the sexual harassment must be. So let's look at this worked example that I mentioned. We've got a woman working in a pub, say, and she is sexually harassed by a customer. And on the face of it, she can't sue for that. She can't sue her boss for that. Or say she's sexually harassed by a colleague, but it's out of time. So again, tribunal has no jurisdiction to deal with it. On the face of it, there is sexual harassment involved in the story, albeit not actionable. She raises a grievance about it, and her manager harasses her about it, but it's not sexual harassment. So you could imagine typical woman always complaining instead of working, etc. Victimization claim for sure, harassment claim for sure, and she succeeds on a harassment claim. It's not a sexual harassment claim, it is a sex harassment claim. So she's through the door, isn't she? Because she's successful in a complaint about the manager's comment. It's a contravention of Section 40, therefore. Was it a contravention which involved to any extent harassment of the kind described in Section 26.2? I mean, plainly it was, because the background to the story is I was complaining about this sexual harassment. So then the employer is put on the back foot to demonstrate the extent to which it was compliant with its duty, with the new duty. But here we throw into perspective some of the issues I was talking about just a moment ago. Say she's harassed by a customer. Say this is a pub that runs 10 different pubs in London. In the pub in which our claimant works, there are signs everywhere in the pub saying zero tolerance of sexual harassment. There are messages that go out to every supplier to the pub. We have a zero tolerance approach to sexual harassment. So in terms of that pub, the employer has taken all reasonable steps. But what about the pub down the road where they don't put up those signs? There's a failure. So again, in theory, even though the claimant is in no way affected by the failure, it's potentially liable in relation to this sort of breach. Now that's an example. This is an example where the sexual harassment is relatively within focus as far as the story is concerned. There's a relatively close connection between the actual contravention, the sex harassment, and the sexual harassment in the background. But what if it's a bit more remote? What if it's something along the lines of manager makes this comment and the claimant brings a grievance about it. And she says in a grievance, 20 years ago, when I worked in a pub, I was sexually harassed by my manager. So when I was again treated like this by my current manager, it was particularly upsetting to me. Is that a case in which, is this a case which involved to any extent sexual harassment? Possibly. It is rather difficult to know what sort of approach tribunals are going to take. Now, as ever with these sorts of problems, you can come up with rather extreme examples. We're going to have to hope/expect that tribunals are going to take a more common sense, more impressionistic approach than the one I have just set out. Hold your breath if you think that's likely. So that's the worked example there. What does the duty in fact require an employer to do? Well, the ECHR guidance does give us some interesting examples, which we'll look at in a moment. What about this all reasonable steps point? Because as Nick said, as drafted, it said all reasonable steps. That was taken out. The statutory defence remains one to take all reasonable steps. So there is that distinction between the drafting of these two provisions. So on the face of it, you would say, well, it's the difference, the distinction has to mean something. The fact that the Lords took out the word all must mean something. But when you interrogate it, it's rather difficult to understand precisely, well, what is the difference between taking all reasonable steps and taking reasonable steps? And I've seen commentators online on this saying, well, there's not really a difference. It does just mean all reasonable steps. And I have some sympathy with that. Aside from the logical points I've made, that there must be some distinction, it's rather difficult to understand exactly what, because you get into these rather absurd questions that I've set out on the slide. Well, how many reasonable steps? It's reasonable steps, plural. So 2 reasonable steps enough? Is it 1? Is it just some? Is it most? Is it sort of a reasonable number of reasonable steps? Well, I think in reality, what we're going to end up with is, again, tribunals taking a common sense approach to this sort of thing, where if in the round it looks as if an employer has done a reasonable job of attempting to prevent the sort of sexual harassment that is being dealt with in the story, they are going to be inclined to conclude that reasonable steps were taken. If you have a situation where there has been a wholesale failure, they're going to be inclined to say reasonable steps were not taken. I would be surprised, at least in the first instance, if tribunals were taking the bold step of effectively exploiting the rather literal interpretation that has led, in my talk so far, to certain rather extreme examples. We don't know, but again, that's the sort of common sense approach we would expect. Of course, in these sorts of cases, one would expect to have a full panel rather than just a single judge dealing with the case. Although, as people may know, the rules are actually changing on that. So you might find single judges sitting on these sorts of cases. But in any event, we will see. The duty, of course, requires that employees have to be protected. Again, how many? Is it all of them? Is it most? What if, in my example of the pub, lots of steps were taken to prevent people working on the bar from being sexually harassed, but not people taking delivery of the beer, or not people in head office, etc. Again, we're going to have to explore that, but I would expect tribunals to take something of a common sense approach. And you'll see in the points I make in the fourth bullet point and the sub bullet points there, again, it's not about the specific sexual harassment, it's sexual harassment at large, which is a point of distinction with the statutory duty. So coming back to the question of the compensation uplift per se, it requires a payment of compensation. I'm just going to flick back. If you look, if the tribunal is satisfied, I'm looking at subsection 3, the tribunal is satisfied that respondent has contravened 40, it may order the respondent to pay an amount to the complainant in addition to the compensation amount determined in accordance with 1246. And 1246 is just the generic provision in the Equality Act that deals with discrimination per se. And as you can see, the power to order any sort of uplift to that award is couched with the word may, so they don't have to. But if they do, look at subsection 4, the amount of the compensation uplift must reflect the extent to which the respondent has contravened the section, although it can't be more than 25%. So what do we make of that? Just go back to the slide. Well, as I said, the sexual harassment itself doesn't have to be actionable. So there's no need for a compensation payment in relation to sexual harassment per se. So in my pub example, the lady succeeds in her sex harassment claim. Let's say she's awarded £5,000 for injury to feelings. Tribunal says there's been a wholesale failure to prevent sexual harassment. We uplifted by 25%. My maths isn't fantastic, but let's say that's a little more, as about, what's that, 1,200 quid extra or something like that. Fine, that's relatively straightforward. But what if we have a slightly more complex claim, and it is, it says, woman works in a bank and she's due £1 million bonus, and she succeeds in a claim that the failure to pay her that £1 million was direct sex discrimination. Fine. But in the background, there is also a non-sexual harassment claim that succeeds. But there is, even further in the background, some sexual harassment. Theoretically, the award of compensation under 1246 includes the £1 million. And let's say the tribunal is satisfied that there's been a breach of the new duty, and it is satisfied that it should make an order. Well, then it has to reflect the extent of the breach of the new duty in that. And of course, even I can do the maths with 25% of £1 million. Theoretically, the claimant could get something like £250,000 added to that on the basis of this breach of the new duty. And you will have noted that because there's an obligation to make the uplift fit the crime, and no obvious proportionality mechanism like you see with the ACAS uplift, for example, this could possibly give rise to a very, very large potential award. So there's a discretion as to whether or not to make the uplift. You see that in the second slide. No obvious proportionality control, although, as I've said on the slide, the explanatory notes to the Act sort of indicate that there would be, but I mean, there isn't. So I think that's wrong, and it would appear to apply to any compensation awarded. Now, I think the slide's probably wrong there. I think it's got to be Equality Act breaches rather than any other form. But if you get a big award for failure to make reasonable adjustments, a big award for direct discrimination, you can have that uplifted. So what you may find is tribunals thinking, gosh, there's been a wholesale failure to deal with sexual harassment for sure. So if we're going to do our job properly, we'd be awarding 20, 25%. But so big is the additional uplift that would incur, we're just not going to make an uplift. So you get a sort of rather perverse incentives there. As we said at the end of the slide, EAT authority required. So I'm going to pass back to Nick to deal with some EHRC guidance, and we'll take it from there.
Thanks very much, Grahame. While Grahame was speaking, I saw that somebody put up their hand, presumably to ask a question. Can I ask if you type it in the chat function, and then we will make a note of it and come back to it at the end, if that's okay. So when I started, I was pointing out that we've had EHRC guidance. Well, it's important to recognise what the EHRC guidance as it presently stands is and is not. And it is concerning that, bearing in mind that the duty comes in on the 26th of October, that the present situation is that the EHRC guidance is not finalised. So what we do have from the EHRC is that on the 9th of July, they produced wording of a proposed amendment to their existing technical guidance document. It was expressly published for the purposes of consultation. That consultation closed on the 8th of August, so over a month ago, and the EHRC response to the consultation remains awaited. So it's important to recognise that at the moment, the guidance such as it is the EHRC's view of matters, bearing in mind that they tend to take an expansive view of their jurisdiction. And presently, it doesn't reflect any of the comments, amendments or suggestions that arose as a result of the consultation process. And I checked last week, and we're still in that situation that the consultation has closed, but no updated guidance published. Next slide, please. But seeing that the EHRC guidance is the best that we've got at the moment, and bearing in mind that the number of persons attending this talk suggests that this is something that's exercising collective minds, the EHRC guidance seems to be the best that we can suggest, and also what employers in particular ought to be looking at in terms of complying with this duty. Now, it's important to recognise something about the reasonable steps defence. By definition, it must have failed, because if it had succeeded, there wouldn't have been the sexual harassment in the first place. So you are constantly looking at a defence with the benefit of hindsight, judging whether reasonable steps had been taken or not, but you are assessing it through a prism where by definition those reasonable steps hadn't succeeded, because if they had, the question wouldn't arise in the first place. So recognise that, because that's an important factor, and it's in the same way in the context of the statutory defence. You only raise it when your steps haven't worked, but you want to demonstrate that you've done everything that you reasonably could. So what the HRC guidance suggests is, perhaps unsurprisingly, that the duty which is imposed on employers is both preventative and anticipatory. So you can't sit there from the perspective of that we live in a utopia where sexual harassment isn't going to happen, and you only need to address matters if something in fact occurs. So as the guidance makes plain, employers can't wait for an incident of sexual harassment before they take action. So what they have to do is, in the first instance, take preventative steps to seek to encourage individuals not to sexually harass their workers. And Grahame will look in a moment about precisely what those may or may not be. And then there's also the recognition that in circumstances where there has in fact been sexual harassment, the employer is obliged to engage with that and see what, if any, further steps can be taken to stop the sexual harassment from happening again. So recognise that the extent of the reasonable steps duty is going to be a movable feast. Because if you are an employer where there isn't much evidence or much risk of sexual harassment, the duties are going to be, in the first blush, probably lower as regards those an employer where sexual harassment is perhaps more likely. And the pub example, if I may say so, strikes me as a good one from Grahame, where that's a workplace where drunk individuals, sexual harassment may be more obviously anticipated than other workplaces. But the movable feast is going to reflect what in fact happens. So if you are in this workplace where sexual harassment could reasonably be considered not likely to occur, but it does, you've then got to engage with that and take positive steps to seek to prevent it. Next slide, please. Recognise, as the EHRC guidance recognises, as indeed the wording of the statute does, is that the duty only applies to sexual harassment, and it only applies to sexual harassment that takes place in the course of employment. So wider allegations of sexual harassment that fall outside the scope of the course of employment, and we all know that that's a wide term in any event as a result of statutory and judicial interpretation of it. But recognise that this isn't a duty to prevent all sexual harassment in all contexts. Next slide, please. Now, here we see the EHRC engaging head-on with the question of whether the new duty applies to third parties or not. I know we've been over this, but just to remind you, there used to be third-party harassment provisions in the Equality Act, which said that if somebody had been harassed on more than one occasion by a third party, liability could attach to the employer. That was repealed in 2013. But here we have an express statement by the EHRC, in accordance with the position adopted by parliamentary sponsors, that sexual harassment includes harassment conducted by or committed by a third party. So when looking at your preventative duty, both on an anticipatory level and then subsequently, if anything happens, on a preventative level, the possibility of sexual harassment by third parties, even though realistically that's something that you can only control to a limited extent, brackets, if at all, is something which employers are going to have to think about. Because if you don't take preventative steps as regards third parties, remember it's all reasonable preventative steps as regards third parties, the duty is breached. Next slide, please. Now, obviously, the question is, well, who's a third party? Now, on the face of it, that could have an expansive definition, or it could be construed more narrowly. Certainly, the EHRC has nailed its colours to the mast and has taken a very, very, very expansive view of what a third party might constitute. So it's customers, clients, service users, patients, friends and family of colleagues, delegates at a conference, and members of the public. So I think we could safely infer from that anybody who is not an employee is going to fall within the definition of a third party in the view of the EHRC, in order to assess whether there's been compliance with the duty or not. And and what the duty, as far as the EHRC is concerned, involves is a consideration of the extent to which workers might come into contact with third parties in different situations, and the risk of sexual harassment occurring in those situations. And you have to take, I repeat, all reasonable steps to prevent that harassment. Now, we're going to go in a moment to a slide or a couple of slides where the EHRC have given positive examples, rather like the example Grahame put forward of the pub worker. And the argument, the guidance then looks at the EHRC's perspective of the extent of the duty to make or to take steps to prevent sexual harassment. And Graham's now going to take you, if we go to the next slide, through these examples and look at what appears to be the very wide scope of the duty envisaged by the EHRC. Grahame, over to you.
Yes, I'm going to look at some of these examples, and they are interesting insofar as they set out, first of all, the interpretation that the EHRC appears to have taken of what the duties are and what they're not. And two, in terms of the examples that they give of things that employers can do or could fail to do in order to attempt to comply with the new duty. And some of them are things which I think every respondent lawyer on this call ought to be thinking, right, how do we get our clients to do exactly that in order to attempt to sort of fend off, before the duty even comes in, any suggestions that it's been breached. So the first example here, we have a large distribution center, staff working in a warehouse. It's not open to the public, but customers can come to collect stuff. Employer carries out a risk assessment to assess the risk of workers being exposed to sexual harassment. You will note here that it consults with employee representatives about the action it proposes to take, implements a variety of measures. You will see the list there of the measures that it proposes to take. There's 5 of them there, all relatively anodyne, I suppose, the sorts of things that people will be encouraging their clients to do in any event. However, look at the 4th main bullet point. Employer fails to consider the risk its workers could be sexually harassed by customers attending the premises to collect orders, despite an incident of such harassment occurring only 6 months ago. So, the conclusion of the EHRC there is employer has failed to consider if there are any reasonable steps it can take to prevent the sexual harassment. It has therefore failed to comply with the preventative duty. Now, a number of points arise from that. First of all, we will all know from claims involving failure to make reasonable adjustments allegations that actually, generally speaking, it does make a blind bit of difference whether you considered or did not consider taking a step. The question with this sort of statutory language is whether or not you did do it. Now, I would quibble, therefore, with this use of the word therefore. Employer has failed to consider if there are any reasonable steps, therefore it failed to comply with the preventative duty. If there were no reasonable steps it could have taken, then it hasn't failed to comply with it. The question is, did it fail to take steps that it could have taken? That's my first quibble with this point. However, as a matter of presentation, employers are going to want to demonstrate that they have considered what the reasonable steps are, because you can guarantee in the heat of the tribunal room, when people haven't really thought about it, some judge or some claimant is going to be able to identify a step that an employer didn't take, and you want to be able to say in that moment, we did think about it and this is why we didn't do it. So there's the first point. Again, this point about third parties is plainly front and center in the mind of the EHRC. They are really plainly focusing on issues where, while steps are taken within the general workforce, within the general day-to-day work of this warehouse, it is the failure to prevent sexual harassment from third parties that causes this employee to this employer to have failed in its duty. Note, though, this point about despite an incident of such harassment occurring only 6 months ago. So there is going to be an assessment, it would seem, of just how likely ought it to have appeared to an employer when the tribunal is assessing this breach. Let's say there has never been an instance of sexual harassment by a customer. Presumably what's being implied by the EHRC here is then, well, in that circumstance, it wasn't foreseeable for the employer, therefore there wasn't a reasonable step. It wasn't reasonable to have expected it to take certain steps. But you can see how there are going to be, in these sorts of cases, bun fights about all manner of minutiae as a sort of thing that employers are going to need to get on top of. The last point I want to make about this slide, anybody who came to our extravaganza last time will know that when I get to talking about steps respondents can take, one of the things I say is consult with unions or consult with employee representatives. And that is plainly something that the EHRC also has in mind. And I can think of no better piece of evidence that an employer could lead than saying, here is the evidence of us consulting with the union we work with, or consulting with the employee representative, or whatever body it might be, where we asked everybody what they thought the risks were and what steps we could take. And no one mentioned this issue, or we did everything that was suggested. So it's rather harsh of you to suggest that we failed to take a reasonable step that even this union didn't think of. So already we're starting to see, in addition to things like policies, training, reviewing the effectiveness of the training, all that sort of stuff, which you would expect, you can already start to see that there are some perhaps more useful things that employers could start doing. Let me just next slide. So, and what does the EHRC guidance say about the reasonable steps that can and should be taken? Well, it's going to vary from employer to employer. I think we've been hinting at that. As Nick said, in a pub environment, the steps you might want to take are going to be rather different, perhaps, than to a warehouse, I suppose a workhouse as well, a warehouse or an office environment, etc. There'll be interesting questions about people who work from home nearly all of the time, things like that. It's an objective test. And the other factors that the EHRC sets out include, if you look at 4, the types of third parties workers may have contact with. So in my pub example, drunk people seems to be a type of third party that you might come in contact with, the likelihood of that happening. So the EHRC is very hot on this third party thing. So that is obviously something that employers really need to have in mind. So another example here is about a theatre company. Sexual harassment of its workers by third parties. Again, all manner of third parties, presumably in producing a show. You can see in the first paragraph, and I'm sorry that there's a big block of text here, which you'll be able to read at your leisure, I'm sure, but it consults with its staff. So again, something that I think is going to be really important. Adopts a zero tolerance policy. Again, that's the sort of thing that I'm sure all employers are going to be saying. It communicates that policy to staff, encourages them to report any instances, develops a protocol for how reports of sexual harassment will be dealt with. Next paragraph, self-employed consultants are all informed of the zero tolerance policy when they contract. And I mean, I've been to the theatre before and I've seen signs in places that say we do not tolerate any harassment of our staff, etc. You can see those proliferating. I wonder if it would be advisable, in addition to saying we don't tolerate harassment, to make a specific reference to sexual harassment in that context. Audiences are advised of the policy in an email. So all customers are being told. Now, you're unlikely to be able to do that in a pub, but you can put signs up possibly. Notices are displayed, as we said. Theatre company considers if there's anything further it can do. It considers engaging an external provider to deliver training to staff on keeping themselves safe in public situations and how to safely intervene if they see sexual harassment happening. However, it decides the cost of the training would use a disproportionate amount of its limited budget. So we see there already, it is going to be relevant that a potential step will not be reasonable if it's too expensive. So that is obviously something. But it may well prove, for example, that a bit of a cottage industry develops of materials that employers can send to their staff, which set out to them the things that the slide mentioned. So how to keep yourself safe in public situations, how safely to intervene if you see sexual harassment happening, the sort of thing that can very easily be pinged out to a whole workforce in order to be able to say, look, these are the steps we're taking to assist. So company small, limited resource, events are infrequent. So the EHRC says it is likely to have taken reasonable steps to prevent sexual harassment of its workers, therefore complied with the preventative duty. So interesting point there. I would reiterate the consultation with staff point seems to be something that is going to be helpful. EHRC guidance on its enforcement powers. I've given it to you there on the slide. I have never once heard of the EHRC using its enforcement powers in relation to its scope, its sort of jurisdiction, if you like. Theoretically, it's possible. I mean, there are plenty of instances. It has plenty of powers to investigate breaches of the Equality Act, which I've never heard of it using particularly. That might just be my experience, but there it is. What I should say is there has been talk. The new government is due to bring in a new employment bill. There has been talk of the EHRC having parts of its functions, at least, merged with perhaps other enforcement bodies. So there may be some movement on just how vigorous the EHRC becomes in pursuing its duties in a way that it hasn't in the past. So an example on compensation. This is a relatively straightforward example. She's successful, a worker successful in a claim of sexual harassment against their employer. Tribunal orders 30 grand for loss of earnings and injury to feelings. But as you can see, this is a claim that is squarely a claim of sexual harassment. Tribunal has to consider whether the employer has breached. Tribunal considers that employer has breached the preventative duty, limited extent, anti-harassment policies, communicated to staff, regular training, didn't review the effectiveness of the policies or training, and therefore 10% uplift, 33 grand. Fine, very straightforward. That's fine. What we don't have here is an example of an employee succeeding in a different sort of Equality Act claim and getting an uplift on the whole award as opposed to a sexual harassment award. But there it is, as we've set out on our reading of the Act, that is possible. So I'm going to hand over to Nick to discuss claimant lawyers preparing. Then I'm going to deal with respondent questions, and then we'll have some questions of your own.
So recognise, for those who appear for claimants, that Parliament has handed you an enormous stick with which you can beat the respondent. Now, putting aside the joy that might give you on a personal level, the reality is that on behalf of claimants, this is a significant shift in the landscape, because all of a sudden matters which very often you'd see in claimant witness statements saying, oh, you know, the institution's all institutionally sexist, or it's this, and it all happened a long time ago, up until this point could easily be dismissed as irrelevant, background, doesn't really go to the issues. Well, now it does. And the thing to be recognised is that employers are going to be nervous, and rightly so, about the new duty and the extent to which the new duty might lead to an uplift in compensation, and potentially a significant uplift in compensation, particularly in the examples of, you know, bankers' bonuses that Grahame gave. So, if there is any arguable relevance of sexual harassment to any claim being advanced by a claimant, This is something that claimant lawyers, in my suggestion, ought to be putting front and centre in their case. And targeted attacks on compliance with the duty are going to hurt. Now, I recognise the point that I made earlier, which is for this to apply, all reasonable steps or the steps taken must have failed. So inevitably, claimant lawyers are going to be able to say, well, there was this sexual harassment, there was that sexual harassment. And so respondents are going to be very much on the back foot in terms of responding by saying, well, okay, it did occur, but because. Now, of course, there's a possibility that your client, for claimant lawyers, might not know about potential allegations of sexual harassment. If they do, you certainly want to be putting this front and centre in any letter before action, and certainly in your pleading. You don't need to plead this, but certainly you should, in my analysis, because what you want to be able to say is, well, look, this is front and centre in our case, so a disclosure obligation applies. The respondent needs to demonstrate what steps it took to address sexual harassment, what what incidences of sexual harassment there were, what they did in response to them. And these are all questions that are going to make respondents uncomfortable, and they might prompt settlement. And if they don't prompt settlement, they might lead to an uplift in terms of your client's compensation. Now, I gave the example of your client potentially knowing about other incidences of sexual harassment, but they might not. And it seems to me that we might see, certainly I would advise claimant lawyers to start returning to something along the halcyon days of discrimination questionnaires, asking questions like how many, what's your sexual harassment training? What are your policies? How regularly your staff updated? What steps did you take to consult with the unions? How many incidences of sexual harassment have been reported? These are all legitimate questions now, which you can properly advance to a respondent in order to say, well, we need to understand this in order to assess the extent to which there's compliance with the new duty and whether an uplift of compensation is appropriate. So I repeat what I began with. You have been handed a big stick, and my suggestion to you would be that you ought to use it. Now, Graham's going to tell you why all of that's wrong from the perspective of the respondent.
I'm not, but I'm going to try and talk about how you might be able to defend yourself against this big stick. So actually, the examples that we've been given through those EHRC examples, I think, are very instructive. And a lot of this is going to be the sort of thing that many employers will have been doing before anyway, educating staff about sexual harassment. Cultural changes that you can demonstrate, clear policies, communication, so on. I've put in capital letters, records, because as ever in litigation, there is no point doing anything at all if you cannot demonstrate it in writing. So make sure that you do it. Training 3 times, and not the beloved of HR online tick box courses, but periodic refreshers, that sort of thing. People who are in charge of monitoring that compliance. Risk assessments seem to be something that the EHRC appears to be very keen on. So that is something that respondents ought to become keen on as well. Reporting channels, they were mentioned in those examples. Training periodically renewed for those who manage and address the allegations. Similarly, support, internal or external, for complainants. The respondents and well, in particular, we lawyers need to keep our eyes peeled for the EHRC guidance as it is finalised and see the extent to which submissions that people have made have been taken into account. But the last 2 points I want to underline: telling stakeholders what you're going to do or discussing it with them. It's this point about consulting with the unions, consulting with employee groups or whatever. If there is a feasible way of doing that for an employer, I think that is going to be a very powerful tool indeed, on top of a well-communicated policy and training that is monitored. And then I leave you with this question about, does this new duty incentivize employers to start taking the statutory defence. And I suspect it probably does, because until recently, as Nick said, we often, when acting for respondents, have thought, well, there's no point because you're not going to win. And we may need or want the particular individual to play ball. And actually, we think they're innocent, or we want them on side, or we are concerned about breaching a duty of trust and confidence to them, all that sort of thing. But in a case where the new duty is going to be front and centre, it may well be thought that if you fail to take the statutory defence, you are, at least in part, or at least presentationally, conceding that you didn't take all reasonable steps. So you may either want to think about taking the statutory defence in circumstances where you wouldn't have before, or you might see that a rather odd line in ET3s now, where we say, well, without prejudice to our contention that we did in fact take all reasonable steps in this regard, we're not taking the statutory defence anyway. That's the sort of thing that we might start seeing, but it's something that I dare say respondent lawyers are going to start pondering. So that's where we are post EHRC guidance. You've got our contact details there, but I think we're going to have some questions, although we're slightly after 10 o'clock, but let's have some questions.
So the first question is from Joanne G, asking, in the workplace, does the duty to take reasonable steps extend to extension of the workplace situations, i.e. colleagues sending messages on work-based WhatsApp groups or non-work related Facebook pages, i.e. should it be covered in the social media policy for personal social media accounts, Christmas parties, out of work, planned get-togethers, training taking place on third-party sites, etc.? I'll take this one if I may, because I've had the chance to look at this while Grahame was talking. And of course, the Christmas party, ever a joyous occurrence for the attendees and for employment lawyers, usually within 3 months, less a day of it taking place. But the wording of the new duty under section 40A subsection 1, there's an employer must take reasonable steps to prevent sexual harassment of employees of A in the course of their employment. So my analysis is the position is going to be exactly the same as the question which is traditionally engaged in those sorts of scenarios, whether it's in the course of employment or not. That'll be a factual question. And so taking them in order, the workplace WhatsApp group may well be in the course of employment. Non-work related Facebook pages, less likely to be in the course of employment. Christmas parties, almost certainly. Out of work plan get-togethers it depends whether it's a get-together immediately after work or separate from work. Training taking place on third-party sites probably is in the course of employment. So, Grahame, anything you'd say in addition to that?
No, I agree entirely. We're going to be falling into and analysing all the same case law about when a Christmas party counts as being in the course of employment as we do with other sorts of claims. So I agree with what Nick said. Some of these questions, I dare say, were asked before we then got to the answer. But so Cassandra Hurley asks, in the context of a school, could sexual harassment by a pupil to a teacher, for example, fall within the ambit of third party? And then Becky Robertson says, or a service user to a care provider. Simple answer, yes, absolutely. They could absolutely be third parties. As Nick said, EHRC guidance says very broad indeed. So unless a respondent successfully takes the point that where the duty refers to sexual harassment of a kind described in 26.2 and successfully persuades a tribunal and then the EAT that only means actionable sexual harassment, and therefore it only covers worker on worker sexual harassment, to coin a phrase. And I don't think they would succeed in that. Only in that scenario would those people not be covered, but I think they will be covered.
So we then got a question from Louise T, which again, I think hopefully we've answered. Is there any consideration of the size and resources of an employer when deciding what's a reasonable step? The answer is yes, there is. And the EHRC guidance supports that.
Interesting question from Nicola Condell. Will there be a potential grace period allowing for confirmation of the technical guidance in relation to, for example, the implementation of updated policies? For example, the semantics are seemingly going to be important along with the duty to consult. So it'll be difficult to implement prior to the October implementation date. Well, I understand. I see what you're saying, Nicola. I think the answer, however, is no, because there has already been a significant grace period. I forget when this act came in, but it was a good while ago. It is unfortunate that the EHRC hasn't quite got its act together to give us full guidance by now. But I don't think you're going to be able to. I mean, the law will apply from the date it applies from, and the tribunal will be implementing its provisions. I don't think you're going to be able to say, yes, I was entirely in breach, but if only the EHRC had given its guidance earlier, I wouldn't have been, so I should be let off. I'm afraid legally that simply is not going to be permissible. So I suppose if there is a sort of a very marginal case where the tribunal is persuaded only by some point of detail or some point of semantic nuance within the guidance, you may be able to say, well, it's not fair to punish this particular respondent for failing to realise. But I mean, I don't know. The law is the law, right? So your interpretation of it, whether it's fair that you should be punished for breaching the law, I don't think you're going to get very far, I'm afraid.
Then we have a question from, I think it's more of a statement than a question, from unknown user, that there are significant issues where two employees enter into a relationship, don't tell the employer, and then split up and things become combative and allegations of sexual harassment are made. Yes. Was onerous on employers before and can only see it getting worse. Yes, I agree.
Yeah, I mean, that's the sort of thing that training and all that sort of stuff, there's going to be an element in there about in-work relationships and all that sort of thing, isn't there?
We've then got one from Nick N. What are your thoughts on the need to consult with employee reps on deciding? Well, I think Graham's covered that in the context of front and centre of his suggestions are consult with the union if at all you can. If there isn't a union, maybe a works council if one exists, or even a deputed group, say to your workforce, we want to talk to you about the problems that you face and how we can address them. And if you do that, as Grahame says, and I respectfully agree, that's got to be powerful evidence in terms of the extent to which you've complied with your duties or not. Next one is those who work from home in, so this is from Joanne G. Those who work from home in, say, a call centre environment could still be at high risk of being subject to third-party sexual harassment by customers on the phone. So would that just require a policy where they can terminate the call and comms to customers not to harass staff, or XYZ may happen, such as call will be ended, contract revoked, etc.? I think the duty of reasonableness has got to recognise the extent to which an individual can or cannot control the actions of a third party. It seems to me that the gold standard would be in those joyous circumstances where instead of having your hold music, there might be we take the protection of our staff seriously, and any sexual harassment of them will not be tolerated and will lead to your call being terminated. I think that would probably be the gold standard, but short of that, I'm not sure what more you can do.
That's exactly what I was thinking of. When they say your call may be monitored for training and whatever purposes, you could also say and for investigating allegation. I mean, that sort of thing. Yes. I can see that being. I don't know. I've never run a call centre, so I don't know how easy that would be to do. I dare say BT could do it. Whether or not a smaller employer could easily do that, I don't know. But that's something that the tribunal is going to take into account. Laura Jane Fowler asks, any thoughts on how good the training needs to be? Well, tribunal assessed the slide pack in Allay and Galen where they tried all reasonable steps defence as being lacking. How will employers know how good bought-in training is? Well, buyer beware, I guess. I mean, if you, obviously, the better the training, the more likely you are to succeed in it. But again, of course, we're assessing the reasonable steps taken. And I suppose if you as the employer, in a broader strategy, say, and by the way, we brought in outside training, okay, the claimant can quibble with just how good that training was. And they may get somewhere with that. But you'd be starting from a strong position saying, we got professional outsiders in to do this training for people. I suppose if every year you had complaints about how poor it was, then you might be on notice that you ought to get an external provider. But I think it'd be rather unfair for the training to be critiqued, you know, in a rather intense way, if the employer has at least taken the step of doing it.
If an employee brought a claim of unfair dismissal and 3 discrimination claims and succeeded in all, and the duty was found to be breached, would only the injury to feelings compensation for the 3 discrimination claims be uplifted, with the unfair dismissal compensation set aside, treated as separate? Well, the answer to that, without wishing to sound like a politician on Newsnight, is that's a very good question. I'm very glad you asked me that. And this is the point that Grahame touched on in his assessment of the compensation provisions. Because if it is the case that you have an award which is related to sexual harassment, in principle, the wording of the statute suggests that you could get an uplift on it. Now, we've got to understand the circumstances, because it's possible that the unfair dismissal might also be an act of discrimination, or it might not. Now, if the unfair dismissal were not an act of discrimination, on the basis of what Grahame said about it seems that the uplift is going to apply to Equality Act claims. If your claims under the Employment Rights Act, Section 40 on the face of it doesn't apply, Section 40A on the face of it doesn't apply, and therefore one would envisage that the uplift wouldn't apply. But it's not too difficult to envisage a situation where the dismissal is also discriminatory, might have nothing to do with the sexual harassment, but to use Grahame's phrase from earlier, it's in the background, and therefore an uplift might be appropriate. Grahame, obviously this was your section of the talk. Do you agree with that?
Yeah, I agree with that. And you're going to have those, you know, we sometimes have cases about when a tribunal is making an award of compensation in relation to a dismissal, in a portion, you know, is that compensation for unfair dismissal, or is it compensation for discrimination? And of course, sometimes there are different tax consequences and all that sort of thing. So that's something that people are going to have in mind as well. I have looked at the Q&A tab. There are actually a few questions that have been put in there. Jim W's is in there. It's actually a rather difficult question. So, so I wish I hadn't looked, but here we go. On Grahame's disjuncture point, does the other failure, e.g. the signs not put up in the pub down the road, need to be in time? Could a failure prior to Section 124A coming into force and or post-implementation, but say a year before the claimant's harassment, be used? Very interesting points. I think on the face of the Act, because, of course, time is a jurisdictional question. So if you discriminate against somebody 4 months ago, you still discriminated against them and breached the Act. It's just that the tribunal has no jurisdiction to do anything about it. And as Nick said, this is not a freestanding cause of action per se. So we're not dealing with jurisdiction over the additional failure, if I can call it that, the failure to comply with the new duty. The tribunal derives its jurisdiction to award the uplift from the existence of the substantive failure, so any form of harassment, plus any breach of section of the new duty. And of course, what the Act says is involved to any extent. So in order to bring it within the scope of the tribunal's jurisdiction, if I can use that word, all you need to be able to say is that the primary contravention involved to some extent the previous contravention. And I see no reason why, in principle, that contravention, the secondary contravention, needs to be in time as far as the claim form is concerned, or indeed needs to post-date the coming into force of the this new duty. I mean, there might be some interesting arguments about that, but the question is, does the primary contravention involve to any extent the secondary contravention? But theoretically, that secondary contravention could be 10 years old, I suppose, on my reading of the Act. But Nick, you may disagree.
No, I think that's right.
So yeah, it's a rather broad and rather strange provision, I suppose, in that sense. Fine, I'm going to go back to the chat ones. I'm not going to, because Nick can't see them. I'm not going to. Okay. I think some of the ones that have been asked in the Q&A we've already discussed anyway. So
the next one is from Sarah L. If the sexual harassment involved in the story takes place before October, but the actionable sex discrimination in which the claimant is successful was post-October, would there be compensation? I think Grahame has just answered that in the context of the question just asked, and our collective view is unless the AT tells us differently, the statute appears to say yes. Then we've got a question from Richard L. Will this new legislation be retroactive? Will it affect claims currently ongoing? I don't think so, because we know that these new provisions are coming into force on the 26th of October. So I suppose your question is, could I amend, presumably, to rely on this duty after the 26th of October? I think my gut instinct in response to that would be no, because at the time that the claim was issued, and also by definition, the unlawful acts upon which you're relying to then trigger the duty under Section 40A, if they predate October, I don't think you will be able to rely on it. Again, Grahame, I think I see you nodding, but tell me if you disagree.
Yes, that's right. Although it's one of those questions where that feels right to me, but actually articulating why that should be the case. So if there's a case of sexual harassment on today, and I bring a claim about it on the 1st of November, say, then I am able to avail myself of the provision, I think. But if I were to apply to amend an existing claim on the 1st of November, well, again, I ought to be able to, oughtn't I? But maybe if it's about sexual harassment that took place.
Yeah, if I may, I think my point is it's not the date of the. I know I mentioned the date of the issue of the claim. It's not the date of the issue of the claim. It's the date of the unlawful act that you rely on for the purposes of the claim, which you would then point to in terms of triggering the new duty. Yeah. So I think my analysis would be, if you are harassed at work and present a claim on the 25th of October, you can't rely on the new duty. But if you're harassed on the 26th or the 27th, you can. Yeah. Interesting question then arises if you have the not unheard of scenario that there's a whole series of allegations of harassment, and some of them predate the coming into force of the Act and some post-date. Then it seems to me you would consider the new duty in the context of the claim, but your argument might be you can't uplift it as regards events prior to the 26th of October because the duty didn't then apply. But that's what I'd argue. Whether the tribunal would agree with it, perhaps be seen.
Yeah, tough.
Next one is there's a number of questions about whether what the 26th of October date means, which I hope we've addressed. There's then an observation from Joe M. Consultation with staff certainly sounds wise, but could elicit significant accounts of harassment. So very sensitive discussions ripe for victimisation, further harassment or trauma. So could it in itself be difficult for employers to handle? Perhaps something to support employer clients with and potentially attend. Clearly a business development opportunity spotted there, and I applaud you. But I think there's some force in that, if I may say so.
Yeah. You've got to think carefully about actually how you go about inviting people to discuss this. I suppose you don't want it to be a sort of bloodletting or an outpouring of trauma or anything like that. But yes, good point.
A question from Dan J. Could steps taken lead to a risk of direct discrimination? Employer decides to arrange work so that female employees do not work with higher risk third parties. I wouldn't immediately see that as a direct discrim complaint. It's probably more likely to be viewed as an indirect discrimination complaint, because if you were looking in the mind of the individual, the reason for the treatment, and going back to Kong, which Grahame and I successfully did in the course of appeal, you're looking in the mind of the relevant decision maker to ascertain precisely what it is that operates on their mind. And I suspect the answer to that would be the avoidance of sexual harassment. Now, that I envisage could be a PCP, which might disproportionately impact on females, which would be subject to justification. The only reason, the first point is, I suspect people wouldn't complain about it unless you were looking at a scenario where, for example, premium rates were paid if you worked after midnight, and the evidence demonstrates that it's in a pub and people are more likely to be drunk after midnight, so there's a greater risk of sexual harassment. Now, if that were to occur, you might have to look at equalising premium rates and the like, but in principle, I think it's probably better viewed as an indirect rather than a direct discrimination complaint.
I think that.
Go on.
I'm so sorry. I was going to say, I think there probably is something in this, because you can imagine a scenario where, for example, you're working in a consultancy or a sort of very client-focused business, and there are plum clients that you want to have interactions with, but they are known to be, they're known to be rather problematic. They're known to be problematic, and so they say, oh well, we won't allow. We'll suggest that the men in the office go and deal with that particular client rather than the women in the office. And so if you're a woman, it is decided that you will not go and see Mr. X, the client, because he's a bit of a dinosaur. And you could say, well, that's a step we've taken to minimize sexual harassment. But in fact, yeah, maybe it could give rise to a discrimination claim, couldn't it?
It could. I stand by. I mean, the moment, as Grahame and I know, the moment you're starting running separability arguments, you are in difficulty. But it seems to me that if you as an employer said, well, what am I supposed to do? This is a client. I either stop dealing with them, and let's assume that they're fundamental to the existence of the business. I send female employees. If I do, I know they're going to be sexually harassed, or I don't send them to protect them. I suspect that a court would be receptive. I mean, it doesn't mean that it'd win, but I think they'd be receptive to a separability argument. I think it's probably better viewed as an indirect discrimination complaint, subject to justification, but I might be wrong about that. But certainly, it's, if I could put it this way, the question is not obviously wrong. That there's an issue that might need to be explored and thought through there. I agree with that wholeheartedly.
Yeah. Matthew Potter, observation, reconsulting staff and trade unions in the McDonald's agreement enforcement with EHRC. They agreed with the EHRC to conduct an anonymous survey of staff, perhaps if no works council, etc., a survey of what protection staff would expect or issues staff have or may encounter, perhaps to gauge the need for training. Sure, yeah, sort of anonymous surveys and stuff like that could well be a very powerful and interesting tool.
And Anne asks, do you consider that an employer should have a separate sexual harassment policy as opposed to including this in the general anti-bullying and harassment policy? Strictly speaking, subject to what's in the policy, I don't think it matters enormously where it is, save for presentationally, your ability to say, we're treating it seriously, and look, we've got a separate policy which we require our employees to read, and it's not buried at page 7 of an existing policy, and they might not get that far. But subject to that, I don't think its location is going to shift the dial enormously.
No, although as a statement of intent, because of course this is the only protected characteristic where you've got this new duty. So if you want to have a sort of bright, shiny thing that you can show to the tribunal, it may be quite powerful to say, and on the 1st of October, we implemented our new sexual harassment policy as distinct from everything else. But it's presentational rather than sort of functional, I suppose.
And I think that's it in terms of the questions.
I mean, there's a few more. Helen says, surely in that case, problematic client, it's up to the employer to sort out the client, not move the woman from the position. Well, morally speaking, no doubt. In terms of answering the question we had about direct discrimination claims, that we gave our legal analysis there. Laura Clark, when settling harassment claims for employees remaining in employment, could we cover previous sexual harassment scenarios in a way to ensure they are not part of any future story? Interesting. I think almost certainly not.
I agree.
Yeah.
I mean, on the face of it, because this is a duty placed on the tribunal, and the tribunal effectively is required to consider this point. Now, I take the point that if the parties don't adduce evidence about prior occurrences, the tribunal won't have the evidence upon which to take a view and potentially uplift. But shall I say, I think it's going to be problematic to achieve that in an enforceable manner. Grahame?
Yeah, I mean, the scenario, I suppose, would be employee is sexually harassed, you settled the claim, and there's a non-disclosure clause. They then, in the future, bring a different claim and they refer to these matters ostensibly in breach of the settlement agreement. Can you sort of do something about that? I mean, you're certainly not going to be able to stop the tribunal from considering it because of the provisions of the settlement agreement, I wouldn't have thought.
I suppose you'd apply to strike out those passages of the ET1 that referred to it.
Sure.
I suppose it's sort of like, you know, you can't, in a settlement agreement, you can't prevent somebody issuing subject access requests because they have the statutory right to do it, but they undertake that they won't do it. And one sees those clauses enforced, as I understand it, although I've certainly seen them often in settlement agreements. I haven't seen any attempt to enforce them, and that may suggest that that's because they work. It's an interesting and not entirely straightforward question.
Yeah, that is a tough question.
My suspicion is that because this is something which is capable of being evidence, I think a tribunal would view that kind of clause with concern and skepticism and probably try and get around it. I think that's probably as far as we could take it in this scenario in terms of advice. And I'm sorry that not as definitive as perhaps you'd like.
Yeah. All right.
Well, thank you. Are those all the questions, Grahame?
Oh, there's one more. Claire McGann, when acting for respondents, I'd be very concerned about fishing expeditions in the course of disclosure. Yeah, well, you and me both. I would hope the claimant has to assert a clear basis on which they would seek the uplift before the disclosure duty applies, ? Well, you can hope that. As Nick has said, on the face of it, no need to plead it. I mean, the tribunal is not going to get to the end of a 2-day case and then say, right, we're now listing 10 further days in order to conduct a public inquiry into how the respondent deals with sexual harassment. And I think that's why Nick says, if you are a claimant, you ought to put front and center what you're saying. But if evidence comes out through the course of the claim that there is an issue here, the tribunal is fully at liberty to explore it, I think, within the bounds of the overriding objective of proportionality and stuff. But I'm afraid if I was a claimant lawyer, I would be saying all the stuff that's in the disclosure questionnaire, as Nick said before. I'd be demanding that the respondent disclose any sexual harassment issues that it had in the past and all that sort of thing. And at the moment, I can't give you any comfort, respondent lawyers, that you can just say, no, you failed to particularize that, therefore it's not an issue. Because I'm afraid the whole purpose of this duty, I think, is to create an environment that really makes life difficult for respondents. So, Nick, I don't know if you agree or disagree.
No, I think that's right. I mean, the reality, it's going to be like any other disclosure argument. That the claimant's going to ask for the world. You're going to suggest that they should have the Isle of Wight, and the reality will probably be somewhere in between. Apologies to anyone who's on the Isle of Wight. Excellent.
Right. Well, thank you, everybody. Yep. That was great. Have a lovely morning. And look forward to seeing many of you at some future Littleton event.
And we suspect that we may, there may be a third iteration of this talk, depending on whether there are or not any significant alterations in the the EHRC guidance. But if there is, it will be talk 3.0, and we will publicise it. And if you're interested, please join us. So thanks very much for your time.
Thanks all.
Bye bye.